I thought that the point of Nieves was, if you have solid objective evidence that you're in a world in which you were arrested for something that somebody who hadn't engaged in your speech activities would not be arrested for, that you should be able to present that evidence to get over the probable cause bar. So here's a hypothetical. Suppose that there were two videos in this case.
Two videos.
The second video is of a meeting with all the relevant officials, and they're all talking about how they can get back at Ms. Gonzalez. And they say, hey, why don't we do this investigation? We'll go arrest her. We'll go, because she moved this piece of paper. And they all agree to that. Are you saying that that can't come in to get over the probable cause bar in Nieves?
No, that's a Lozman claim, and there is a Lozman claim pending against the city.
Well, it's not a Lozman claim against the city. It's the same defendants here.
Oh, it's just officers agreeing?
Yeah, it's the same defendants, but there they all are on videotape agreeing how they're going to retaliate against Ms. Gonzalez.
That was the Nieves complaint, is officers Waite and Bartlett, I hope I have their names right, or Nieves and Waite were conspiring to get this person. And so you just didn't have them on videotape.
Yeah, well, now you have them on videotape. That seems like pretty good objective evidence to get you over the probable cause bar. I mean, I guess what I'm suggesting is that the point of this probable cause bar is we don't want every old allegation of like, they had a bad intent and they were trying to look at, but if you have solid objective evidence that you were being treated differently from another person in your situation, that solid objective evidence should, and part of that might be comparative in the way that you're suggesting, but there might be other things too.
I mean, the problem is this is a poster child. There is absolutely nothing in the complaint that suggests that either the chief of police or this police officer had any reason to even know who this woman was or her
You're
speech.
fighting the facts.
But that's what this case is going to govern.
Justice Kagan's asking you a hypothetical question. I'd be grateful if you'd answer it.
Sure. The problem with this anything goes.
It's good I have an enforcer.
Yes.
Because I can let you get carried away doing all this other stuff.
And your question
But I had a hypothetical, and it was a good one.
Because you're a good advocate, and every advocate is going to hire you or somebody like you who's going to say, my evidence is really good. Look how these people were out to get me. I'm an unpopular figure. This is a small town. I didn't like the road construction.
No, now you're still fighting.
Sorry.
Yeah.
Okay, on your other hypo.
You don't need an enforcer.
Any hypothetical, it is going to be, I was picked on, and I'm going to be able to cite any evidence that's anything but, I guess, an officer's subjective statement. Yeah, because that's the only thing you specifically ruled out. And the court, I think, said very clearly only comparator evidence. Once you have a similarly situated person who's not engaged in speech.
Well, look, you don't have to, from my videotape, you do not have to make a very long leap of inference to say, oh, that's comparative. This videotape is like, let's go get Ms. Gonzalez. You don't have to say, and we wouldn't have gotten everybody else. It's obvious on its face that this is treating Ms. Gonzalez differently.
And what I'm concerned about is the next hypothetical where the plaintiff, like in Nieves, says that officer said to me, I was out to get you. Or I'm so glad, it's time to arrest you. I've been waiting. I mean, we all know that the government.
I mean, now you're going to the statements that obviously are not coming in under Nieves because they're just statements that the officer made reflecting his state of mind at the time. So
isn't the only difference? I'm sorry, maybe I understood your hypo. Isn't it only because there's a videotape of the officer's statements?
Well, it's pretty clear, objective evidence that a judge can look at. Which makes it clear that Ms. Gonzalez was picked on because she was doing what the First Amendment allows her to do.
I worry that if you write an opinion that says only that evidence is okay, if you've got the officer on videotape, that's fine. I worry where you're going is anything that I, as a judge, think is pretty relevant that she was picked on. That's what scares me, and that's what scares me representing police officers who literally, are trying to work to get the community to trust them and do their job and don't, have the smear campaigns every time they're sued.